Assalamualaikum, my name is Nur Nadira binti Zulkarnain, metric number 2009555513. Local Government Act 171 may be characterized as an act to reform and harmonize the laws connected to local government in Malaysia. Aside from that, the Act is helpful for the only purpose of ensuring the equality of law and policy in making law with regard to local government, and it is the principal act that controls the duties and privilege of local government in our country. The Local Government Act of 1976 is divided into 16 parts and 166 sections. Local Government Act 171 in Peninsular Malaysia is governed by uniform legislation passed by Parliament under Article 76(4) of the Federal Constitution. This is due to the fact that local government elections have not been held since they were terminated in 1965. Local government is an act that was enacted to check and integrate the laws pertaining to local government. The goal of the Local Government Act 161 is to provide uniformity of law and policy in the creation of a legislation governing local government. The Local Government Act of 1976 must only apply to Peninsular Malaysia. The Local Government Act 171 is the primary act in Malaysia that governs the rights and activities of local governments. It gives all local governments the authority to carry out their tasks in order to assist and enhance the performance of local governments in terms of their functions. According to the Local Government Act 171, the five main provisions of local government, which are policy and decision makers, protect the interests of the people, attend the full council meeting, oversee the overall running and administration of the council, and representative of people in council.
Assalamualaikum, my name is Nishani Saina binti Sharijam with matrix ID 2020984319. For my part, I will be presenting of the main provisions in the Act 171 that relate to its representative functions. Function 1, Environmental Protection and Building Control, with its Provision 9, Public Places. Environmental protection and building control refers to the responsibility of municipal governments in managing environmental divisions. Environmental protection is critical because it is linked to the security and social well-being of residents in the region. As it is a highly serious subject and difficult to enact policies and supply services to the public, the local government has concentrated on this sort of obligation. Furthermore, there are other environmental challenges that require careful and decisive action on the part of local authorities in the region. One of several obstacles that occur in the local region is the problem of waste material, which is typical in the most of Malaysia's local regions. Since there are so many and disposal takes so long, the local government is having difficulty managing and disposing of the waste material. The Municipal Council of Subanjaya, for example, has an issue with workers working on building sites unlawfully discarding rubbish from the ongoing development. As a result, local authorities in that region have taken legal action against anyone who engaged in unlawful behavior. As a consequence of the problem, it can be concluded that the problem of waste material is still a concern in most Malaysian localities. Building control is the responsibility of the local government to inspect and evaluate the requirements, needs and safety of a structure to ensure that it meets its standards. A local authority has general supervision and responsibility of all locations within its jurisdiction that have been or will be set aside and entrusted in the local authority for the public's use, or to which the public will have or will obtain a customary right at any time. Function 2, Public Health and Sanitation with Provision for Food Markets Sanitation and Nuisances. Public health and sanitation in Malaysia, the Ministry of Health is in charge of healthcare management, which is organized into federal, state and district offices, also known as local authority. The State Health Department coordinated and oversaw the establishment of the Department of Health. Ultimately, the District Health Office, in collaboration with the District Hospital, is accountable for providing public health or facilities in districts, since the District Hospital also has an obligation to the residents of the district. A local government has the jurisdiction to construct, manage and operate sanitary services for handling with wastewater. They also have the right to seize, decimate or throw away of any buildings, stalls, tables, showboards, wheel loaders, carts, three-wheelers or other compartments, whether stationary or not, established or used for selling or disclosing for sale of any food or drink in sidewalks, public areas or public accommodations resort, or products other than food or drink in sidewalks, community centres or places of public resort if they are not so licensed. Any landlord, occupant or tenant of any residence, building or property, whether tenable or not, who allows similar or slightly any aspect thereof to become filthy and unclean, or overgrown with rank or noisy foliage, shall be guilty of an offence under section, on prosecution to a fine not exceeding 1,000 ringgit, or to both such imprisonment and fine, and to an additional fine not exceeding 100 ringgit. The local government shall take efforts to eliminate, cast aside and subside all public nuisances on public and private property within the local jurisdiction, and may bring legal action against anyone who commits such nuisances for abatement and damages.
Assalamualaikum and hi, my name is Najibah Najia binti Mat Amir Hamzah. Today I will present about my part, which is problem arising and actors involved. The local government is responsible to make sure the increase in the quality of the environment is less than their own territory. This responsibility can be seen through the point of view of the environment regarding cleanliness, the management of constant natural resources, consistent and effective, and also consideration towards any forms of threats or distractions. This environment and safety problem is important because it requires the people to live within the territory. Next, local governments must be more flexible in meeting local needs and being able to bring them according to their functions. Other than that, to make sure the services are always at the maximum quality and judgment on their performance required, according to KT 2008, the efficient allocation of funds by local governments remains a big problem to be labelled. Nevertheless, in Malaysia, the local governments are on condition that local services mention that they manage stage of policy decisions. Several problems may force organizations to estimate customer satisfaction, which people normally are not well up on of the procedures and expectations that local governments services perform in line of service delivery. This lack of slight cuts off governmental effectiveness and creates many opportunities for dishonest and unaccountable practices as some of the main problems in Malaysia. Besides, this is why the government categorized it as being deliberate, administrative and rarely groundbreaking. According to Andrew 2003, identifies areas of cover to consider customer satisfaction in the public sector. The announcement of the Town and Country Planning Act of 1976 was a brave step in the history of town planning in Malaysia. It not only amended the Local Government Act of 1967 but also introduced a supple form of planning replacing the inflexibility of the city planning concept. However, the interim development plan does give some guidelines for the straight urban development of the local authorities. The government is actually giving emphasis to the preparation of the interim development plan for the development of the medium and smaller city. For instance, the emphasis is in agreement with the new economic policy objective of poverty eradication, since most of the rural poor live in areas within or on the edge of the district councils. This is likely provided the plan is able to put up their social well-being.
Assalamualaikum, my name is Kushanaim bin Muhammad Sofi from group AM110 with the card matrix number of 2020-956-879. Okay, so for my part of the presentation, I will be elaborating on point 4, which is recommendation based on government and group opinions, which is in a sense of improving as well as enhancing the local government. So to start it off, as we know, the Local Government Act 171 prioritizes the enhancement in terms of efficiency and effectiveness of local government in Malaysia. This is because despite the strong advantage of the local government, there are still a variable of disadvantages that can be found in the local government. For instance, the performance of the local government is more than always criticized by the public, which are Malaysians lah in the sense. This is because the local government can be proven to be rather slow and ineffective from time to time, especially during crucial times. One example is during the progress to overcome the COVID-19 pandemic, our local government was slow to react to the current issue. Okay, so the first recommendation needed to enhance the efficiency and effectiveness of the local government is through the appointing of professional individuals, especially with the proper education to serve in local government such as city council, municipal council and even district council. In Malaysia, most people can see that the people that are running the local government are far from deserving their job roles, as they are usually people who tend to obtain the roles through the help of others from the same local government. Hence, when undeserving individuals play a part in the local government, this will inevitably lead to a slow and ineffective performance, as they do not possess the skills to effectively carry their work. In the Local Government Act 171, it is highlighted that there are no requirements for the appointment of professionals for those who are residents to the local authority. Furthermore, in Section 10 of 2, of the Local Government Act 171, it is crystal clear that the state authority possesses the power to appoint anyone and anybody as long as they deem them as a person who has achieved distinction in any profession. This can be rather unfair, as the person in power can choose anyone based on their personal bias instead of the other more deserving groups of people. Thus, the process of appointing new members into the local government should be free from bias, as a way to further gain trust from the public that the people in power are able to promote good governance through this way. Secondly, another recommendation worth noting is to provide workers from the local government a proper training through various mediums such as profession workshop. Through this recommendation, the local government may be able to further improve the skills and training needed for their employees, where their competence will ultimately be enhanced for their respective work scope. These trainings and workshops can vary from anything such as proper computer class for the workers to improve their IT skills, which is the computer and information technology lah. To no surprise, many individuals are yet to master their basic computer skills, such as mastering and understanding application on computers such as Microsoft Office, which we know as Microsoft Word, Microsoft PowerPoint and even Microsoft Excel. These applications are crucial in every workplace, at least considered as an application needed in everyday routine at work. For example, an activity from work that needs Microsoft Office is data entry, as we know. The local government, as a big institution, should provide these trainings and workshops to cater for the employees who are lacking in certain skills. This will then further strengthen the local government as a whole, since their employees has the access to greater improvements. And then for the third recommendation is by strengthening the local government's management of employees in terms of their qualifications. This is to ensure that their employees or staff are fully capable of carrying their jobs with full responsibility, as well as being able to fulfill what is needed in their respective jobs with maximum efficiency and effectiveness. It is obvious that qualification and quality is very important, from obtaining a job to fulfilling the job to ensure safety in an organization. This safety is meant as a safety from getting fired from the job role. The local government is fairly comfortable with the audit system known as KPI, which is short for Key Performance Indicator. However, a disadvantage to this system is that the local government will only go through the list of KPI only at the start of the year or at the end of the year, which is far too late or far too early to properly adjust to what needs to be fixed. Therefore, the recommendation is to strengthen an audit system through learning from its advantage, which is to continuously study the KPI list and further study which employees are worthy of staying and which employees are needed more trainings before executing them from the local government. So for the conclusion for point 4 is that finally, these recommendations are highly crucial in terms of enhancing the efficiency of the local government as a whole. Through these recommendations, surely the local government will overcome its weaknesses, which eventually prove to the public that the local government can be a reliable source of management. That is all from me. Thank you.
Hi, Assalamualaikum. My name is Muhammad Dinar Shah bin Zaidi from AM110 and my matrix number 2020952201. So I would like to presenting about my part, which is conclusion. So firstly, the Local Government Act 171 is very useful and effective in administering the Malaysian government system because it can increase the effectiveness and efficiency in enacting laws in Malaysia. The Local Government Act 171 is used to enact laws and regulate the affairs of local authorities by placing full discretionary powers on local authorities to enable them to carry out their function of state administration, town planning, and development control within the area of responsibility by local authority. Furthermore, the power entrusted to it is very important for the administration of the country because it is also to identify the local authorities in bearing the losses arising as a result of negligence in the crimes committed. Therefore, this given power cannot be left alone without the control of the responsible parties because it can cause problems and the abuse of discretion. In addition, analysis has been made in the case law so that it can corroborate the fact of discretionary power are not entirely independent of judicial control and judicial scrutiny. So therefore, local authorities need to be prudent in exercising their powers within the prescribed limits of power by state law so that the court are unable to question the decision made by them. That's all from us. Thank you.